a very rude indulgence of from me tonight. My father's just got a traffic accident, so I have to leave my phone on tonight, my husband's on the way there, so I just want to get the status, that's all. Okay, because I just knew about 15 minutes ago. Okay, but fortunately, I heard it's not severe, okay? But yes, this is the only time I'll beg for the indulgence. Hope you're okay with that, okay? Now, presumably, they just want me to hold on to it because tonight there's no clip. Okay, so be it. Okay. As last time, I think I'm just going to click from here. I won't bother getting them to. Okay, not working. Okay, now. Revision. Okay, I'm not going to go through this. You know that. We'll get straight to the Okay, now just a revision. Last time I told you that there are 4 types of originating processes. What is the purpose of originating processes again? Now I've talked with some of you on Saturday afternoon. I know you guys are not this quiet. Okay, so what is the purpose of originating processes again? It's the document by which you. Yes, it's the document by which fireworks happen. Okay, it's the commencement of a civil case, and you do that by getting it stamped at the High Court or District Court registry. Okay, so 4 types here. The most common type being writ of summons. Thank you. And the next popular one is probably the originating summons. Okay, OM is very rarely used. Petition mainly for winding up and bankruptcy proceedings or divorce. Doesn't sound very good, right? Everything's breaking down or financially unsound. Okay, so petition either winding up petition, bankruptcy petitions, or divorce proceedings. Okay, writ of summons. How long is it valid for? Once you have that stamped, it's called issued. And once it's issued, it's valid for 12 months, 1 year. And if you have been lazy or you need more time for one reason or another, the 12 months is expiring, you can apply for an extension, yes. And that extension normally will give you another 12 months. Okay, you should do that before it expires. Otherwise, you need a little bit more, you need permission, or it's harder to explain. Okay, okay. So, and what did we say? Once you commence the action, you have that originating process issued, whether it's let's say it's a writ. You have the writ issued. It has the effect of stopping what running. Remember I said it's hard K, right? It stops the limitation period from running. So if you have the 3 years or 6 years or whatever, let's say it's a simple contract case, meaning just normal contract, not by deed, then you have the 6 years limitation period. And if you issue the writ just before the 6 years time bar, then it's okay. You don't have to worry about it anymore. Okay? Of course, you have to proceed with your case. But that is sometimes one of the reasons why people issue the writ first before serving. Sometimes, because now today we're going to look into detail the statement of claim, all those pleadings, the storytelling documents that we mentioned last time, the statement of claim, the defense, the reply, etc. Okay, so for those, we need information, right? Sometimes we need, because my example last time was in the traffic accident, the injuries have not stabilized, or for contractual breach, you need you need some more to gather some more evidence or documentary proof, etc. So you're not ready for the statement of claim yet, and you don't want to alert the defendant yet. You want to serve him in one pack, bang, okay? So that may be the reason. Okay, I think you know this, we've gone through this. Okay, the difference between, or when you have to decide whether to use writ of summons and originating summons, what's the major distinction, or what would be the major reason or factor that would determine whether it should be a writ action or an originating summons? Imagine that the rules did not prescribe that you have to use one or another. You have a choice. So if you have a choice between writ of summons and writ of summons or originating summons, what factor? What's the major factor that determines which one you use? Whether, louder. Substantial dispute of what? Of facts, right? Yes, substantial dispute of facts. Because writ of summons involve more complex procedures. Those procedures are actually, apart from interlocutory extensions, applications, etc., most of those have to do with evidence. Okay, most of those have to do with evidence. And so that's why. Okay, so writ of summons involve more or substantial dispute of facts, whereas originating summons more or simpler case. Similar case, or it's more on interpretation of documents and so on. And remember, in case that the court thinks, you started it by OS, originating summons, but the court thinks that you should have started it or commenced the action by a writ action, because it turns out there are a lot of factual disputes. Then the court can direct the action to be like transformed, right? To proceed, we say, to proceed as if it had been begun by writ. So the court can do that, okay? The case number may not even change sometimes, okay? It may remain an MP, or it may remain one way or another, okay? You see more, in reality, you see the case of OS, if the court thinks it should have been by writ, to be changed into a writ action. But actually, in reality, although they can also change it from writ to OS, it occurs less frequently. Because if you have a writ, you have those choices still of all those applications, interlocutory applications. If the case is simpler, the parties simply do not take out those applications. It's still okay to proceed. Do you get what I mean? Right? It's just more choices available in terms of applications, interlocutory applications. Yep. Okay, the other thing that you should remember is, what were I trying to, okay, let's take that out. Another quick revision question. What are inter partes applications as opposed to ex parte? You should remember that from last time as well. First of all, two types, right? Ex parte and what's the other one? Inter partes, right? Don't forget the S, and that helps you to remember as well, right? So, what's the difference again? Anyone?
Two parties versus just one.
Sorry, I appreciate the participation. Oops, this time only one microphone. Oh, here. Okay, if you don't speak up, I'm going to take the microphone to you, okay? So I have to run around. So can you speak louder? You were saying inter partes are?
One has two parties, both of them are there, plaintiff and defendant, the other just has one. Or is it available?
So all the parties in the same case are before the court.
Yeah.
Yes, thank you. So all the parties are in front of the court for that hearing. So you hear, okay, is there a difference between interlocutory applications and interlocutory hearings? Well, after you make that interlocutory application, right, it's an application, 申請, right? Then when it comes to the time to hear that application, it's the hearing. So essentially it's the same thing. So you hear me sometimes say interlocutory applications, sometimes you hear me say interlocutory hearings. Essentially the same item, right? It's just whether the process of applications or the hearing of that application. Okay. Okay, now getting back to where we were with pleadings. Remember where we are. First of all, whenever you look at procedures, think about where you are in time. Okay, you find that whether you study contract law, tort law, whatever, always remember the timeline, whichever your legal study is, whatever that subject is. Okay, same thing with civil procedure, actually even more so, right? Because everything flows in one direction towards the trial and beyond. Okay, so after we kickstart the action, we have pleadings. Now, in terms of the writ, we also have to have a look at what we have to do with it. We said we issue it, and then we have to serve it. Okay, that's the only document when you talk about all these legal civil litigation documents. We don't file because it's actually issued out of court, right? We call it issued. Everything else, I've reminded you a few times now, is either filing or serving. Filing is filing with the court. Serving is serving on the other parties. Yes, correct. So it can be plaintiff to defendant, defendant to plaintiff. At this stage, in the beginning, of course, is the plaintiff to the defendant. Okay, so the only other terminology you may hear about handling things around is exchange. And if you hear that word, you probably guess it's the parties exchanging. I'm the plaintiff, you're the defendant. We exchange our witness statements at the same time. Essentially, that only means, yes, we serve on each other, those documents, at the same time when we say exchange. That's the only difference in terms of time-wise. Okay, I think we went through this just very, very quickly. Again, pleading is a legal document. Theoretically, you can define it as to give notice, to define the disputed issues between the litigants, and so on. There are actually very detailed rules. Actually, in civil litigation, there are detailed rules and guidelines on everything. Okay, have any one of you seen a white book? The traditional legendary white book? Okay, I'm not going to bring it to class because it's about, the whole volume is about this long, this thick. Okay, in about 1, 2, 3, 4 volumes. Okay, it's like a Bible for civil litigation. At this level, we don't expect you to go and look for it. Everything that you need to know for exams are here, and your course manual. Okay, for your assignment, which I apologize, it's not ready yet, but I promise I will have it ready before end of lectures, and so that I will have a chance to discuss it with you. Okay, to be fair. So we've talked about all this. Basically, no ambushing, no surprises, right? The spirit of civil litigation. Okay, duty of disclosure by all parties. Same thing. It's all about everyone being very ready, open, and transparent. We've talked about this also. Again, no surprises. Each side knows exact case they have to meet. The nature of the case, meaning, what's the nature of the case? I know it's a contractual breach. How much can it deviate? Okay, so because you know it's a contractual breach and it's not the plaintiff will suddenly at trial bounce up with another. Oh, I'm also going to claim as breach of duties or employment or fiduciary duties, etc. Okay, so you know exactly the scope that you have to, let's say, defend yourself or so. No surprise again. Know how much the scope of evidence that has to be prepared. Limit and define the issues to be tried so the trial itself won't last for weeks. Right? If people jumble around everywhere. Now, last time I didn't really go into plead facts, not evidence. Okay, plead facts, not evidence. Now, pleadings is a story. Okay, so basically you're saying once upon a time, right? Except you're giving a time, right, for everything. Okay, so if there is a concise statement of material facts, notice the word material and notice the word facts. Okay, so if there is a contractual breach, I use Tommy a lot. Well, I abused Tommy and Mary last time. Let's find someone else to abuse. What's your name? Angela and Candice. Okay, Angela and Candice, you are my girls tonight. Okay, so Angela and Candice, contractual breach case. Okay, so Angela, just the simple non-payment case. Okay, and Candice ordered no iPhones tonight. Candice ordered 1,000 projectors. Angela delivered. Candice didn't pay, one of those simple ones. So what are the material facts again? What would you say? Where would you start from? What are the essential elements of a contractual breach? Offer and acceptance, so there must have been a contract, right? So you would talk about how the contract is formed, on what date, right? Date, time, parties, and because it's a contract, you would talk about the contract's terms. The terms at least the terms that you are seeking to rely on, right? Probably the price, delivery date, quantity. Yes, agree? And what else? So you have contract, you have terms, you would have Yes, you would talk about, those are all included in the terms, right? The price, the quantity, you're correct. And the delivery date, right? If we're saying that the breach is non-delivery, or if it's non-payment, we'll say the due date, right? Those are the terms, payment due date, right? We're saying non-payment, right? So when is the payment due? And the amount. And then we talk about the goods have been produced and delivered, right? So that one side performed, well, Angela performed her part. So contract has been performed on her part. And then what do we need? Breach, right? So next we talk about how Candace was naughty and didn't pay. Okay, so the due date has gone past, and the typical things you say would be, then Candace didn't pay, and then you probably add some details about Angela did make a few demands and still she didn't pay, and that's why you commence action. And then you would probably also talk about how much is the claim, right? Is it just the non-payment or the balance payment, or is there some other loss you suffered because of that? So those would be material facts. Now, what would be non-material facts? Well, if you want to say, yes, you were on essential background facts, time, date, contract entered, parties, do I need to know that you were at the Starbucks in Sheung Wan, near Hitler Street? Do I need to know that? Probably even if it's 3 p.m. or 3:30 p.m. is probably not important as well. Just the date is important, right? Because it goes to delivery or payment. Yeah, so you understand what are material facts. Okay, plead facts, not evidence. Now, a lot of students although you don't have to do drafting now, but sometimes when we go to PCL, some students get caught. Okay, facts and evidence, how do I distinguish it? Okay, for example, if evidence is how, facts are what happened. Evidence is how to prove the facts happened, that actually happened. You support your allegation of facts with evidence. So, if I say, if the contract was entered by, rather than sitting together, you two enter the contract by correspondence, by email, do I need to reiterate the whole content of the email? Right? I probably don't need to tell you, by which computer, and the whole content, if it's not relevant, right? Those would be evidence. Okay, so that's that. Or you don't have to talk about your account ledgers when you say that Candace didn't pay, right? Those would be evidence, right? Your account ledgers, how you bookkeep, no need. Okay. Define, identify, limit issues. Okay, yes, we've talked about that. Enable the court to understand the real dispute between the parties. Enable the parties to have, yes, it's all repeating. But that's just because this is all well summarized in this case. Okay, Korean Exchange Bank and another. Remember that means another? And SSCP Holdings. Okay. Remember the chronological order, right? Statement of claim, defense and counterclaim, reply, and defense to counterclaim. Now, out of interest, I just think it's hilarious because last time I was trying to tell you how rare rejoinder is, right? How rare rejoinder and surrejoinder are. Well, I was trying over the I think last night to find the Chinese translation because I actually needed it. And from the judiciary, out of those Chinese judgments, I can't find any. Okay, so that just goes to show it is actually quite rare. Okay, at least not at high court anyway, high court cases. Okay, those are quite rare. I think it would be called something very similar to 被告人第二次抗辯書 or 再抗辯書, but there's no formal identifiable term on that. Okay. Anyhow, you don't have to, for this course, you don't have to learn the Chinese name of it anyway. But just for you to know, this is 申索陳述書、抗辯書同埋答覆書。Okay, but just for you to get an idea, but you don't need it now anyway. Okay, so apart from that, I think we went through that enough, right? We're going to go through each one individually later, and I'm going to show you samples. May also include, what do we mean? Mean pleadings. Apart from statement of claim, defense, reply, it can also include requests for further and better particulars and answers to the request, to that request. Why do we have requests for further and better particulars? Now, it's actually because the pleading was not done or was not drafted well. So let's say Angela, as the plaintiff, has drafted, okay, and later filed and served her statement of claim. However, she has missed some material facts, which are considered essential. So the defendant, okay, statement of claim by Angela, so the defendant, Candace, makes a request for further and better particulars in relation to that statement of claim that Angela has filed. Do I make myself clear? It's because this statement of claim missed some material facts. So Candace is saying, hang on, I don't exactly know the case I have to answer. You need to tell me more. So he's making clarification. Candace is asked, as the defendant is asking for clarification of the statement of claim by making a request for further and better particulars. And so guess who's making this? Angela. Okay, now it's you. Okay, Angela, in response to that request, is furnishing the answers to the request for further and better particulars. It's just answer to that.
Do I still have a chance to defend after the
Yes, yes, yes. You're saying, hang on, Angela, you're too vague. Okay, you're missing some statement of claim. For example, perhaps Angela didn't specify the total amount of goods or price. Okay, so hang on, how much are you claiming me? Okay, so you're asking for further details, and then after you get the further details, you would make your defense. You would prepare your defense and file and serve. Okay, same thing. It can happen to any one of those. Okay, so if, of course, reply stage. Okay, so if the statement of claim, Angela was very good, it was drafted very well, but instead the defense was not drafted well. Okay, so perhaps Candace is saying, okay, the goods were defective. That's all. She didn't specify how, what amount, quantity, etc. Okay, whether they're workable and how much loss she suffered, but she wanted to counterclaim. So this time, if the defense is vague and missing some specific or material facts, it will be Angela, okay, because defense is by the defendant. So the plaintiff is going to, hang on, defendant, your defense is vague. I can't prepare my reply, right? So the plaintiff will go and say, in relation to the defense, I'm making a request for FNBP, okay? And then Candace would be answering that, okay, providing the answers. That's all. Okay, so it depends which pleading was not clear enough. Flowchart, again, we love flowcharts. Writ is, notice the pleadings are in the bluish background, because this is not a pleading. This is the originating process, remember? And this is also not a pleading. It's almost like sending a receipt. It's sending an acknowledgement of service of the writ. Okay, so we don't call it acknowledgement of service of the writ, but essentially that's what it is. Okay, it's the defendant telling the plaintiff, okay, yes, I got the writ. Okay, I acknowledge my receipt of the writ or being served the writ. Okay, so the pleadings you can see here. Okay, of course, the requests and the answers to requests for FNBP can happen at any stage. As I said, it depends which document is not clear. So the FNBP can happen here or here or here. What else? General principles when what you should keep in your mind as principles when you draft pleadings. Pleadings should not be unreasonably long. Should not be unreasonably long. When you prepare a pleading, yes, this sounds like just common sense again, Vivian. They are. Well, you need to understand your client's goals so you don't go on irrelevant stuff. If the facts you're pleading does not support your claim as a plaintiff, why bother? Okay, if it doesn't advance your case, don't go sidetracking. You lose the other side. Define issues, set out factual basis of the claim and/or defense. Now, I can't stress enough the importance of pleadings. We've had enough contracts, right? So, negligence claims. What's the elements again? Sorry, I'm making this like a revision class. Oh, no. Duty of care, breach, and causation. So guess what? You have to have enough facts to support your claim. Okay, so you have to have duty of care, breach, and causation. Let's say it's a, sorry, I keep on using traffic accident because that's the quickest way to comprehend. So because your typical exam question is always, well, at least in CPE, is always traffic accident. Not for diploma, I'm not sure. Okay, so traffic accident, negligence. If your claim is negligence, then you have to, well, how do you give facts to support duty of care? Let's say it's a traffic accident. Do you have problem questions in tort, in your obligations? Yes or no? I can't remember. It's too long ago. Have anyone seen the past exam papers? No? Okay. Okay, let's say that in reality, okay, we're drafting a statement of claim based on a traffic accident. Excuse me. So as duty of care, do you know Nettleship and Weston, the case? Have you heard of it? Okay, it's about an established category of duty of care. Yes, you know that, right? Sorry, I also teach tort tutorials in CPE, so my occupational hazard. So you know that you don't use caparo if it's an established category, yes? Okay, so in tort, if you have, I'm venturing too much. Anyhow, okay, Nettleship and Weston gives you an established category or principle that all motor vehicle drivers on the road owes a duty of care to all other road users, whether those other road users are pedestrians, other motor vehicle drivers, bicycle riders, or just pedestrians. Okay, so if it's a traffic accident, all you have to show to raise a duty of care would be that the defendant was a motor vehicle driver on the road, on a public road, right? So then, and the victim, the plaintiff, is another road user. That's all you need, right? So plaintiff, pedestrian, defendant, motor vehicle driver. That's good enough in the same vicinity. Okay, breach. So you have to somehow give enough facts to support that the motor vehicle driver, in that case the defendant, was not exercising was driving below the standard of a reasonably prudent and careful and competent driver. Okay, something like that, right? Agree? Okay, so that's, well, how do you do that? Perhaps you actually, or there's a witness seeing that he was using the mobile phone. Perhaps he was running across red light. Okay, red traffic light. So that would all count towards breach, right? Agree? Okay, have I lost you? No. Okay, so breach and then causation, injury, right? If you show the victim's injury, that would probably be good enough. And you show that there's a direct linkage from the accident, right? He got hit and then went to hospital and suffered whatever injuries. So you get all your elements. So that's what you need, right? Other supporting factors may be that, for example, that it was a clear sunny day, the pedestrian was crossing the road according to pedestrian traffic light, things like that, right? To show that there was no contributory negligence. So all those would be material facts. Okay. But you probably don't need to say that, yes, it's Chinese New Year, unless the road traffic is specifically very different, right? Exceptional. You probably don't need to talk about unless it's very strange weather conditions or it was unusually crowded, exceptional circumstances. Otherwise, you don't need all those ancillary bits and pieces. Okay, so that's what I mean by the factual basis of a claim. Accurately inform your opponent about your client's case. Aim for precision so that it's not unduly long. Aim to be comprehensive. Okay, so this too is a balance, right? Conciseness and comprehensive. Comprehensive so that you have all the facts you need. Because what is it? The plaintiff, if you miss an element, your claim will fail. Formality requirements. Now I'm just going to go through this very quickly because you'll be able to, I'll show you a sample anyway. So it would bear particulars of the action title, as in which court is it being commenced in, the parties' names, etc. Right? Names and addresses of the party or solicitor, action number be signed, divided into paragraphs which are numbered consecutively, so 1, 2, 3, 4 running consecutively. Contain each allegation of fact in one paragraph. That's what most claimants or most pleadings fail to do. Okay, they jumble facts together. Express some states and numbers. So these are very particular detailed rules about how it should be to make everybody's life easier. Contents, again, summary of the facts, material facts only. Oops. Not plead matters of law, but may raise a point of law. That tends to be quite difficult, but you don't have to worry about it until you actually draft. What it actually means is that, let's say the traffic accident example. You would talk about all the material facts. You're not supposed to go through the legal principles in your pleadings. Remember, it's telling a story. It's not arguments yet. You leave that for later. You wouldn't, for example, you talk about all the background, right? Like just what we said, time, motor vehicle driver, holding mobile phone, running through traffic lights, like that, those type of material facts. What you will not do is, because you won't run legal arguments, you won't say, yes, Dimitri is my favorite, right? D for Dimitri. Dimitri was was driving a motor vehicle at the time, so he owes a duty to all others. You don't run legal arguments. Okay, it is not a submissions. It's not legal submissions. However, you may raise a point of law. You can say that Dimitri was negligent because he was running through red traffic light. Okay, he was not paying attention to the traffic. That goes to negligence also, right? Not plead irrelevant matters. Not plead matters that cannot be supported by evidence. Now, when you go to trial, your allegations of facts, whether whichever way, your allegations of facts must all be supported by evidence in any disputed factual issue. If both parties agree that it was 31st of December 2020, it's okay. You don't have to argue the date. It's agreed, right? For anything that is not agreed, the weather conditions, whether the defendant was holding the mobile phone while driving, those can all be factual issues or disputes. And when you have factual disputes, you will need evidence to prove it, and the other side will try to disprove it, right? So you may say, hang on, I don't have a cam recording, right? Or the car, or I was walking on the road, I wouldn't have video recording of what happened. Well, it can be any kind of evidence. Remember, it can be documentary evidence, photos, recordings. It can also be eyewitness. It can also be the victim's testimony as well, right? Those are also oral evidence that will be contained or prepared into witness statements as well, right? But one way or another, if you haven't seen it, if the victim didn't see it and there's no eyewitness, you can't just suddenly allege that, I think he must have been talking on the, you can't guess, in other words, right? It must have some basis. Now, while we say that you can't plead law, there are certain legal issues that we expect, or the court expect or requires you to state out. So it is, remember the word to use is plead. Matters which needs to be specifically pleaded. Okay, fraud, defense of set-off. Defense of set-off is very similar to the claim and counterclaim, where the claim and counterclaim is very closely linked based on the same event, same factual background. They can set off one another, right? This claim of $1 million, the counterclaim of 200,000. If it's founded, it can be used to set off the original claim. Okay? 抵消啊. Okay? 互相抵消. Illegality, if the contract was for an illegal purpose. Okay, the agreement was for an illegal purpose. It can go and destroy the root or the basis of the contract, right? And it may even be void ab initio. Limitation, as in limitation period issues. Contributory negligence, as you know from tort, if the victim or the plaintiff is also partially to be blamed. Exemplary damages, those are based on certain issues, punitive, almost punitive nature kind of damages. Interest, okay, those all have to be specifically pleaded, as in you have to spell it out that yes, because of that we'll be relying on the issue of illegality, etc. Right? It will be spelled out rather than just talking about the facts supporting that. You spell it out. If the matters here are not specifically pleaded, the court will not infer. Okay, it will not make inference. 唔會推斷. Okay, will not infer the existence of those matters, and the party will not be permitted to rely on them. Okay, so you cannot argue those issues at trial. In those circumstances, because if it is important to you, whether as a claim or defense, you will need to get the court's permission to amend the pleading. As well, a party cannot contradict his own earlier pleading. So just because you feel like changing your story, you can't suddenly make a big swerve. Well, how can you swerve? Well, let's say on the plaintiff's side, you have a statement of claim. And then after the defense, you may think, hang on, I don't think that was a good version of events. Let me think of something else. Okay, you can't suddenly change your whole story or events. Okay, you in your reply, right? That would contradict your earlier statement of claim. Okay. Criminal conviction. We talked about last time how criminal conviction results from a higher standard of proof, right? Beyond reasonable doubt is definitely stricter and higher hurdle. So if the defendant from that traffic accident got a conviction of dangerous driving, which is very, very serious, then it would support your civil claim because you only need a balance of probabilities, right, to show that he was driving dangerously or negligently, etc. Okay, now before we actually turn to individual pleadings, we need to look at writ of summons a little bit more to see what is normally handled or bundled together when you serve the defendant. Okay? Again, writ of summons is not a pleading, it's the originating process. We've talked about issued within the 12 months period. Now, okay, wiki, start to pay attention now. We are going to look into timelines a lot more. So once you get lost, it's tougher. Okay, so when you serve the writ, you would, when the plaintiff serves the writ on the defendant, it must be accompanied by an acknowledgement of service. Sometimes you will hear me say that as AS. AS. Okay, also called Form 14, but as long as you remember the word AS, I think that's better. An admission form, that can be either Form 16 or 16A. We'll look into that later also. Why is that? Remember, that's like a receipt. That's like an acknowledgement. Yes, defendant saying, yes, okay, I got, you served me the writ. I acknowledge, okay, I confirm I received it. Admission form is if the defendant doesn't want to dispute the claim. Even it's not, the defendant's not disputing the claim, not disputing the liability or quantum. Admission form. Okay, cut short the whole process. No need to fight anymore, right? If you're making a claim, she's admitting. No, why would you need to prove and disprove and go on the rounds and rounds of process? Okay, so the defendant by this form is saying, okay, yes, I will. I have nothing. Or the defendant think, okay, I have nothing to defend myself anyway, so I might as well admit to save all the cost. So in this, by this form, they will say, yes, I admit the quantum, I admit liability and quantum, and they can just say, yes, I'll pay, or they can also suggest payment terms, like, yes, I know your claim is 1.5 million, but I don't have so much cash now. I propose to pay it off in a year or 6 months, and however amount, whatever amount, monthly. Okay, so they can do that. Once they receive this package, this tool with the writ, the defendant must then sign the AS, acknowledgement of service, within 14 days. Now, 14 days is quite short a period, like for legal process. So indicating whether defendant intends to defend the action. If not defending the action, they should indicate whether the court should stay the proceedings. Okay, if they're not fighting, they're admitting, they're just going to go through the arrangements or admin to pay or pay in installments or in one lump sum, then there's no need to fight, and there's no need for the court to devote any more resources going on, right? So they should pause. Remember, stay means pause. S-T-A-Y, stay, okay? Two types of writ, okay? Two types of writ. One is called specifically endorsed writ. Now getting to terminology, so wiki, okay? So specifically endorsed writ is a writ which contains the statement of claim inside, okay, incorporated. Whereas generally endorsed writ, it has a very brief one-page statement about the claim, but it's not a full statement of claim. Now, I think you have a sample in your course manual which runs like a page, but in reality, a statement of claim doesn't run a page. Okay, so from a few pages to over 100 pages, okay, depending how complex the case is. So again, incorporated the statement of claim and not incorporated. If it's not incorporated, guess what? It means the statement of claim will be served on a different occasion. And all this, because you're not allowed to give a writ without stating what your claim is, right? You can't just serve a writ, 俾張告票人，又好似抄牌，又唔知又唔話俾人聽你抄乜嘢， right? You can't just you can't just sue somebody without telling him what you're suing for. So even a generally endorsed writ will contain a general statement. Normally, it may only say, oh, let's say in the contractual claim case, yes, the plaintiff is claiming against the defendants for non-payment for the price of goods unpaid for the supply of 1,000 projectors delivered when. Perhaps that's all. Okay, to give a very succinct background about what the nature of the claim is and the relief sought. Okay, so and then the second sentence may be the plaintiff seeking the non-payment of goods to the total amount of $1 million, $1 million Hong Kong dollars plus interest, something like that. Okay, the statement of claims serves separately and must be consistent with the nature of the claims under the writ. So it's very common for that general statement to be very vague, because you do not want to limit your statement of claim which is to come later. Defendant, upon being served of this generally endorsed writ which doesn't have the SOC, may serve notice on the plaintiff, requiring plaintiff to serve an SOC on D within 14 days of issue of the notice. To say, basically to turn around to say, hey, don't be too slack and too slow. I want to know what the claim is all about. Okay, let me see. You have a writ and an AS. You have a writ and an AS. Are we going to go through? Okay. You may want to have a look at the writ in your course manual, but it's very, very brief. Okay, not like a typical one. That's the sample writ. Well, you look at that page, you can see that it's on page 97. Okay, have a very quick look. I'll show you some real ones. Okay, but you can see that it's called writ of summons. It has action number, court, and other writing of the action number, normally right hand corner, and this here. Parties, plaintiff to go first. Dan Black, defendant. It will have the name and address of the defendant, and also should have the issue date. Notice 12 months validity. This is actually supposedly so is this a specifically endorsed writ or generally endorsed writ? Very good. Okay, specifically. Okay, might as well remember in specifically S with statement of claim, right? S with a statement of claim. Okay, remember, use any tricks to help you study. Okay, so statement of claim, here it is actually very brief. Nowhere like in the real world. Okay, this is a dishonor check. Okay, what I said, a bounce check, basically, 彈票. Okay, because in law, this is a very simple claim because a check should be as good as cash. Under bills of exchange kind of law, those banking and finance law, a check should be as good as cash. So if you cause a check, your check to be bounced, the other side can straight away claim you. They don't need to prove a lot, unless they are alleging fraud, unless you're alleging fraud or total failure of consideration for the check. Otherwise, it's very hard for you to defend. Okay. See, all they have to cite is one section of one ordinance. And claiming the amount, interest, cost, dated, this is the admission form. Okay, but I think we can look at it later. The AS is on 107. Okay, this is only directions. On page 107 is only the directions to fill in the AS. Okay, so for a defendant facing a claim, the very first thing they do is to fill in the AS, which starts on page 109. The actual filled form is on 109. Look at the full name, Acknowledgement of Service of Writ of Summons. That's what it's acknowledging. Say the full name of defendant, blah, 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 blah. State whether the defendant intends to contest the proceedings. Yes or no. Once you take it, it's binding. You can't go out back and say, once you say, no, I don't want to defend, you can't go back and say yes. Okay, once you filed that AS. And then they will give you further questions. If the only remedy is liquidated amount of damages, do you intend to admit and make payment, etc., etc. Okay, it automatically says service, printed here, service of the writ is acknowledged accordingly. Okay. Can you anticipate the reason behind why a party might issue a writ and yet withhold serving it on the opposing party? I think we've sort of explored it last time. What can be a reason? Actually, we thought about two reasons, right? Why we want to issue a writ. Why we want to issue a writ and then not serve it yet. The time bar, yes. Okay, the time bar is probably one major factor. Okay, it's probably one major, the single most important factor of why somebody would serve the writ and, issue the writ but not serve it yet. Perhaps they want to wait till they're ready to do the statement of claim as well and serve it together as well. Okay, getting into some real action. Statement of claim. State your grounds and basis. Again, your PowerPoint, any differences in PowerPoint is because of perhaps copyright issues. I haven't given you a copy of pictures, they're not so important, etc. Okay, otherwise your handout is essentially the same as my PowerPoint. Plus the activities, right? Because it's only for discussion. The statement of claim is the main pleading of the plaintiff. Because, well, you may say, hang on, the plaintiff also has the last say. Right? What does the plaintiff have prepared? The statement of claim and what else? What's the other pleading? Statement of claim, defense, and then? Reply? Yes? Okay. So, but in reply, they should only respond to the defense. Right? The reply is for the purpose of responding to the issues raised in the defense. You see later why I say, well, can't I say more? It's difficult. I'll show you why later. Okay, so this is the battleground of the plaintiff. So again, all the material facts, how the action arose, why the plaintiff has the right and defendant has the liability as against the plaintiff, and what kind of remedy or relief is sought. Now, personal injury cases only for this. When serving the SOC, the plaintiff must also serve a medical report and a statement of the special damages being claimed. Okay, special damages, that's very particular to personal injuries, specific items of claim. Okay, so some special requirements. Let's not worry about the S. Let's see, is that the last slide for the SOC? Oh, yes, that's so quick. Now, let me show you a tip. Who wants to see a real one? Nobody. No response. I've lost everybody. Okay, now let's see some real action here. Here. Okay, we don't need that. I have multiple ones to show you. Now, because of confidential issues, of course, I've changed the numbers and the name. So you see some italics here, okay? So is it big enough for all to see at the back? Is it okay?
You can make it a little bit bigger.
A little bit bigger? Yeah. But you won't see much if I turn any
Oh,
bigger.
oh, that's good. That's good.
Is that okay now?
That's good.
Okay. Now, just like what you've seen before, that's the writ, the front page of the writ. You see, this is the typical, this is a district court one. Okay, the seal of the district court, you can see. So once it's stamped, it's issued from the court registry. Normally they would have the solicitor, if it's legally represented, if the plaintiff is legally represented, they will also have either the person's name if it's a litigant in person or if there's a solicitor here. Statement of claim, this is a, oh, okay, this is a sad case, casino debt, okay? It's a casino debt case and talks about how the defendant basically went into casino, borrowed money, and didn't repay. I guess that's the gist of it. Okay, so that's an agreement, like a loan agreement, okay, similar to that. Okay, have the terms being relied on. So you don't, of course, you do not need to plead the whole document because not the whole document is relevant. Probably just to say how payment would be due and the interest and so on. Okay, how the debt arose, what's the outstanding balance, entered into the agreement, and now the outstanding balance of the loan is 2.9 million. Entitled to 80% per annum interest based on the loan agreement. Okay, right, well, it's called credit agreement, but basically it's like a loan agreement or facility. If you're claiming interest, most often you will also say from which period to which period, because sometimes during different periods, different percentage would apply. Okay, some is because, yes, it's based on the loan agreement. Some is because once I get judgment, it's another different rate called the judgment rate would apply. Okay, so if you have further an alternative case on interest, this part, okay, from here up to paragraph 11, from 1 to 11, remember what we said? Facts, only material facts. So, and the paragraphs must run consecutively. Can you see? Numbers must be expressed in numerical figures, as in Arabic figures, and date. Figures, and not in words. This part, okay, what is this part? What is this part? What is here? When you sue somebody, you are after remedies, right? This is the relief of remedies, but in legal jargon, we call this the prayer to the court. Okay, pray to the court, please give me. Okay, so the date, signature. If you're legally represented, it's normally signed by your solicitors. And nowadays, you need also to sign, this is, I might as well show you, this is what a statement of truth looks like. Now, statement of truth is just a verification. Okay, it's basically just to verify that the facts in the statement of claim or the defense or the reply or the further and better particulars are true to the knowledge of the party. Now, normally it should not be signed by the solicitor unless it's necessity, such as the plaintiff in person is actually overseas or something like that. If wherever possible, the statement of truth should be signed by the parties themselves, the relevant parties themselves. If it's the plaintiff should sign it. If it's a company, normally, let's say a director will sign it. Okay. So in here, it's a company. So let's say I, Peter Wong, director of M&M Casino, of the director of not the plaintiff. Okay, director of department of the plaintiff believe the facts stated in this statement of claim is true. That's all. If it's the defense, then it would say the facts stated in this defense are true. That's all. Okay, and here, oops, doesn't have the back page. Where's the back page? Okay, this is what we call the back page. I need to make it small so they can see it. Okay, I know you only see a vague sort of image, but basically it has the same heading, and it says writ of summons, or if it's statement of claim or defense, it will show here. Okay, normally this is writ of summons and it will say issued, but if it's a statement of claim separately, or if it's a defense or reply, it would say filed on. Remember, the writ is the only one we say issued, the rest we say filed and served. So it will say filed on 15th of October 2020, like that. Okay, solicitor's details, that's it. So that's what a real one looks like. Okay, this is what it would look like if it's multiple parties. Just first defendant, second defendant, third defendant, so on. Okay, again, this one is a High Court one. It actually says, it's too small, it actually says you have to say whether it's monetary claim or tort or land or mixture. Sometimes they give both the English and Chinese version together of the standard package. Now this is A. Is this a specifically endorsed writ or generally endorsed writ? Who says general? Hands up. Who says specifically endorsed writ? Good, nobody. Okay, as long as this is not called a statement of claim, you've got a generally endorsed writ. Pretty clear, right? So only where there is a statement of claim, a proper statement of claim incorporated in the writ, then it would be, the whole writ would be called specifically endorsed writ. And, no, endorsement of claim is just a brief statement. Okay, if it is generally endorsed writ, which means no statement of claim incorporated, then that endorsement of claim is only like a statement. It is not a pleading. Only the statement of, it's very strict civil procedure. If it's not within what we said, it's not. Okay, so only statement of claim and defense and counter defense and reply, etc. This is a water leakage case, leaking into a beauty salon. Okay, so this is actually for a generally endorsed writ, it is pretty detailed. It actually went over 1 page. Normally you would expect it to be half a page to under a page. Okay, otherwise they might as well do a statement of claim, right? If it goes on and on. Now let me show you by, what's it called? Negative, a bad example of how you should not be. Because remember we said that endorsement of claim, still you have to let the other know, let the defendant know what the cause of action is, correct? Now tell me, due to well, it's either tort or contract. Here it's tort anyway, because it's water leakage. Is an eruption of a sewage pipe a cause of action? It's not. Okay? In actual fact, it's not. Perhaps they just want to state the background without being confining what their causes of action is, but it's not really a cause of action. Eruption of a, you can say that it's water leakage due to negligence or the like. You need to, yes, we don't want to have so specific legal arguments, but you still need to state your cause of action. Right? Even in a traffic accident, you still talk about negligence or contributory negligence. Right? You can still mention on that. Here, eruption of a sewage pipe, it doesn't even say who caused it. So it's very, very vague. Vague at its highest, right? Vagueness at its highest, although for the prayer, it's quite detailed. These are all the prayers, because it's against 3 defendants. For your information, in this case, the plaintiff is the beauty salon, into which in whose premises the water leaked into. The first defendant is actually an incorporated owners,業主立案法團. Okay, and the second and the third defendant, I think one is like registered owners, basically, of the unit. Okay, because the beauty salon is actually a tenant, and some of its equipment or beauty equipment and machinery got damaged. So it's also claiming against the registered owners, who are the landlords. Okay, so this is a long endorsement. Okay, the rest is just like standard, right? Including the statement of claim. And it would, see the 16 and 16C. 16C is for unliquidated damages, and Form 16 is for liquidated damages. Let's look at this later, it's too detailed. Okay, so defense. Now let's go through the theory, and then you will, once I show you the sample, you will know exactly what I mean by why should one paragraph why should, in the statement of claim, why should there only be one allegation of fact in each paragraph? Because otherwise it makes the defense very hard to prepare and pinpoint the allegations. The defense is the main pleading of the defendant. Not overdue yet for break. The defense is the main pleading of the defendant. It must be served by the defendant within 28 days after the date on which the AS is filed, acknowledgement of service is filed, or the SOC is served, whichever is later. Why do we have sometimes SOC and sometimes AS? Because it depends whether it's a generally endorsed writ or a specifically endorsed writ. Okay? If the SOC is served later, then you can count from the SOC is served on the defendant. Well, notice it's not filing. Remember the difference of filing and serving? Right? Serving is on parties. Filing is with court. Okay, I'm sorry, I'm hammering into you. So why do we count from service and not from filing? Let's say the SOC is separate. Okay, so it was a generally endorsed writ, and the SOC came later. Why do we, when we count the deadline for the defendant? Now, Angela, you've filed and served your SOC. Okay, you issued the writ and then you filed and served the SOC. Now, why do we count from serving on Candace and not from filing? We give the defendant 28 days after this SOC, let's say. Okay, for example, we get after your service of SOC on Candace, we give her 28 days within which she must file her defense. Why do we count from service and not from filing? Just from the definition of filing and serving. Well, what if I file with the court 1st of March and I only serve on her 10th of March? Right? If I'm being mean and naughty and just malicious against Candace, right? I serve her 10 days later after I file. If I count from filing, she's got 10 days less, right? So that's why it's only fair we count from service. Makes sense, right? Now, I tend not to read out every single time all the rules. Alarm bells, you must cite rules, okay? Formal announcement here, you must cite rules. Any case law that are relevant to support your principles or rule or procedures, you must cite case law or rule numbers. We normally doesn't distinguish, and as I said, you can just keep on citing rules of High Court, RHC. So you don't have to remember two sets of rules. We only give one set to you anyway. But yes, you do need to remember the rules, okay? And cite in exams, okay? As well as assignments, okay? Now, the defense being the main pleading, the main storytelling opportunity of the defendant must respond to every single allegation in the SOC. Okay, have the chance to set out all the material facts relating to the defendant's case. For any allegation not responded to, the defendant is presumed, quite conclusively, to have admitted the SOC allegation. So you must put up your shield or even counterattack, right, for every single allegation. Bear with me a little bit more. Once we see a real sample, you'll see exactly what we mean. You have three choices. Angela is saying Candace didn't pay. For that allegation, Candace can admit, not admit, or deny. Basically, for every single allegation in an SOC, you must handle it by one of these three ways only. No fourth option. What are the differences? If you admit, I think we all know what admit is. We agree to the allegation made. Candace is agreeing, yes, I did not pay. Okay, perhaps she'll come up with reasons why, but essentially she's saying, yes, I did not pay. Perhaps she would say because the goods were defective, no, it was an empty container, or whatever. Okay, there was no goods delivered, etc. But in terms of you saying Candace didn't pay, Candace saying, yes, I admit I did not pay. Agreeing to the facts pleaded by the plaintiff in the SOC, no need for plaintiff to prove that particular allegation anymore. So you don't need to go about and show in your own way with evidence she did not pay because she admitted, right? For whatever reason, she'll state more. She'll explain further perhaps, but at least on that payment or non-payment, she's agreed she did not pay. Not admit. Not admit is usually used when the defendant has no positive case to put forward. And the defendant is saying, no, I don't know much about that. Put aside the payment, right? Because payment she should know, right? Whether she paid or not. We'll use an analogous example later. Defendant has no positive case to put forward. Defendant is saying, plaintiff, I don't have information on that, but I don't agree to your allegation. You go ahead and prove it. I'm just standing sideways. Okay? I don't have any information to rebut, to disprove your allegation, but I'm not agreeing to it. I'm just crossing my arms. You go prove it. For example, last time when we say, when we use Tommy Construction and Mary's case, inspection. Remember, Mary didn't pay for the goods and saying that it was defective. And actually, Tommy Construction turned around and said, no, I had independent, SGS, okay, an independent inspection company. I had a third-party independent inspection company came and inspect the goods. They were good. Okay, let's say that is Tommy's case. Well, with Tommy's case, when did Tommy? Where would it have? It was before shipment, right? The inspection took place before shipment at Tommy Construction's factory. So would Mary not have been there? Would Mary have been there when the inspection took place? No. Right? 驗貨嗰時喺 Tommy 嗰度㗎嘛。Right? So Mary wouldn't have known it. So Mary can't say, no, that didn't happen, because she was not there. She can't say, right? She has no evidence. She can't even give oral evidence because she knew she wasn't there. So what can she do? She can just say, well, I don't admit it. So I say not admit. I'm not admitting it. You go and show proof that the inspection took place and it was by a third party and that 100% were inspected. You go and prove it. Okay? That is also called putting Tommy Construction to strict proof. Okay, putting him to strict proof. So this is normally used when that party has no information. Okay, but it's something unfavorable to her. Deny. We all know what deny means. Candace saying, no, I paid. Okay, let's go back to the payment issue. D puts an affirmative case in answer to the allegation. And the defendant must state further facts to say why my story is different from how you say it. Okay? Okay, so the defendant must state his reasons for denial and put forward a different and positive case. We say a positive case because I have something to say. Okay, so so perhaps you're saying Candace didn't pay. Candace say, yes, I did. I sent you a check. On whatever date, the check number is what? Okay, so Candace is denying your allegation, and Candace is putting forward a positive version of events, directly different to your allegation. Okay, so that is denial. Now let's look at a sample. Reply, defense. Now once you see a sample, you will know what I mean. Okay, let me put that up. Again, real life case, district court case, numbers, parties, I won't repeat. Defense. This is just a defense and no counterclaim. Okay, so unless it would normally, because this is the second pleading, it normally adopts the abbreviations and definitions of the statement of claim to make things simpler. If it has new terminology, it can also make some new definitions itself. Okay, so where applicable, the defendant is a bit small. Can everybody sort of see? If you really have to come up, feel free to, okay? But I think most of you don't want to leave your seat, but here, unless other normally adopting the abbreviations, etc., it would say reference herein to number paragraphs are references to the paragraphs in the statement of claim. I use SOC because I've already defined it here. Paragraph 1 is not admitted. Notice that there is no further thing I want to say. Not admitted. Yes? Can you see? Paragraph 1 is not admitted, just being, I keep silent. Now paragraph 2 is admitted. So that fact, but I want to say something more. So for both admission and denial, you can choose to say more. Denial, you have to say more, because you're disagreeing. If you just want to admit, do the simple action of admitting, you can also choose not to say anything more. Okay, but here we do. This is actually, I think this is a fraud case, if I'm correct. This is one of those fraud cases I tell you about, the money being passed on and then dissipated, etc. And this is one of those tracking money case. Okay, tracing the money. Okay, the defendant company was actually the receiver of the fraudulent funds. Okay, but it's saying that it received the funds because in the course of its business while trading on something, on normal everyday contracts in its everyday course of business. Okay, 佢話佢做緊正當生意攞俾佢，基本上 okay? Okay, the defendant is company incorporated and there is a boss. here are not admitted. Well, the defendant actually doesn't have to say that. The defendant has no knowledge in respect of the matters pleaded in the said paragraphs. Okay, you don't really have to say that if you're not admitted at all. Prior to So we're talking about, yes, the defendant is in proper business, engaging in dealing with normal course of business. Actually doesn't say what. Multimedia players, related products manufactured by defendant, etc. So in other words, it's saying that, no, I was acting in the course of my ordinary business, and those money I received because I produced and delivered some goods to somebody else. So those were legitimate money received. That's what its defense is all about, here at least. Okay, so here, paragraph 11 is denied. You have to say something why you deny it. Why you say that the money is not the plaintiff's, but it's mine, and I receive it in my ordinary course of business. It's for the goods sold and delivered to the other party, to another company. And therefore, the defendant was entitled to receive it for legitimate reasons. Okay, so basically that's what we don't have time to go through really the content and the story. Okay, but just to show you how it is. Why do I say there can only be three choices? You can see that it is ever going to be only one of those three. Okay, denied, denied, not admitted, or admitted. Okay, that's basically what I want to show you. Okay, where there is a counterclaim. Excuse me for a minute. Okay, good. Where there is a counterclaim, I just want to see how. Okay, we have 45 slides. Where there's a counterclaim, what is it? Is a claim brought by the defendant against plaintiff? I think we've explored an example last time. So instead of plaintiff claiming against the defendant saying, hang on, I have something related that I want to claim against you. Okay, it's usually connected within the same factual matrix, okay, based on the same events. It's normally issued together with the defense by the defendant, and therefore it is called defense and counterclaim. It's governed by Rules of the High Court, Order 15, Rule 2. Do I have one to show you? I didn't know that. What do I have? Oops. Oh, there's a defense and counterclaim. So in a defense and counterclaim, what you have is the title may be called defense and counterclaim. Normally here it would actually have, now it's naughty, it should have a wording defense here. Okay, so after the main title defense and counterclaim, it would say defense here, go through the defense, and the separate section it would have counterclaim. Okay. Normally it's based on the same events, so sometimes the defendant will just turn around. Based on the events mentioned above, we're making a counterclaim against the plaintiff. Sometimes they have additional facts here as well that they will lay out and plead. Okay, this is also for payment, I think. This is a mock sample anyway, so that's why I can show you. Okay, so the setup is pretty much the same, except that it will be separated into two sections. Defense should be here, and counterclaim. Okay. Okay, after we have defense, let's have a break after defense and counterclaim. Set off. Set-off also is very much related to counterclaim. It's a monetary demand made by the defendant against the plaintiff's claims. And normally it arises, the basis is the counterclaim. May be raised in respect of monetary sums because only then you can set off in figures, right? You can't set off if I want, that's one bulldozer and then another something else, another piece of land. You cannot set off, right? It's only in money, in dollars and cents, you can set off the numbers. So that's why it would only be raised in respect of monetary claims. If successful, it will reduce or extinguish the plaintiff's claims. It's one of those under Order 18, Rule 12, it has to be specifically pleaded. A defense of set-off should be clear as to the debt or amount that is sought to be set off, preventing the chance of surprising the opposing party. So in other words, it's got to be clear. That's all. I think we're due for a break, and we'll come back after that on reply and defense to counterclaim.
I still have some questions.